A recent dispute between the Air Force and a simulation software subcontractor proved an important point. The government has rights to certain intellectual property by challenging so-called markings. Notes on who can do what with images, drawings, technical data. Haynes Boone's procurement attorney Dan Ramish joined Federal Drive host Tom Temin earlier with more on this case.
Dan, this is one of those cases that sounds really arcane, markings on technical drawings, but you feel this is an important case for government-wide. Tell us about it.
Sure, Tom. So when commercial products and services companies provide technical data that relates to their commercial products and services developed exclusively at private expense, contractors are entitled to grant the government a limited license in that data. But there are certain categories of data that the government reserves broader, in this case, unrestricted rights to use the data. And one of those categories is data that's necessary for operation, maintenance, installation, and training, as long as that data isn't also detailed manufacturing and process data. So the government is different from commercial buyers in that it buys a lot of stuff that is going to be around a long time. And the government needs the ability to make sure that it can make full use of commercial products and services, and also is able to have the information needed to maintain it if it's going to be in place a long time.
In this case, we're talking about training software for the C-5 aircraft, which is old and will be around probably for another generation or two.
Yes, that's right. Training simulators for the C-5. And the visual system specifically was being supplied and replaced by this company called Flight Safety. Now, when a company provides technical data that pertains to an other than commercial item, something that's government unique, there are specific legends that are required to be used on the data so that it's clear what rights the government has in it. When it's a commercial product or service, the clauses don't specify any particular markings. And so this case is important because the court addressed what types of markings are permissible and what restrictions there are on the types of markings that contractors can use.
In other words, the contractor had marked it up in a way the Air Force felt was too restrictive.
That's right. So the traditional approach has been for commercial contractors to use the same markings they use in the commercial marketplace. And in this case, there were a few different markings that were included on these drawings that were delivered by Flight Safety. There was a long form marking that described the drawing as proprietary material and included a copyright marking with a statement that said all rights reserved, and asserted that the documented information that it contained was confidential and or proprietary to Flight Safety. Then there was also language that said it shall not be reproduced, distributed, or disclosed to others except as expressly authorized in writing. There was also a shorter form marking that just said Flight Safety proprietary rights reserved. And these sorts of markings would be fairly routine in the commercial marketplace. They're necessary when you're attempting to protect trade secret rights in documents to make it clear to the recipients that they can't just provide them to whomever they want, that there are limits and that they can't use or reproduce them or disclose them in an unauthorized way.
Now, there's a practical question here, though, too, isn't there? Because who else would the Air Force share it with? There's nobody in the world that operates that particular plane except the Air Force.
Right. So the way these things often work, Tom, there are components, say the visual system, that may be used in a commercial aircraft simulator as well. And so often there are commercial components of a government unique broader system. So that may well be the case here. Clearly, there was no question that the drawings here related to commercial products that were offered to other commercial customers. Okay. So we assume some sort of commercial simulator application.
We're speaking with Dan Ramish. He's a procurement attorney with Haynes Boone. So how did this all come to a head then?
So the Air Force argued that these drawings were necessary for operation, maintenance, installation, and training. That's referred to in the data rights realm as omit data. and they said that they weren't detailed manufacturing and process data. As this dispute kind of developed, the Air Force challenged the markings and said, well, because these are OMIT data, we have unrestricted rights to use them and are not limited to using them only within the government. And so therefore the Air Force told flight safety to remove the markings. Flight safety ultimately provided an alternate marking as an alternative that said it provided the U.S. government unrestricted rights only pursuant to certain DFARS provisions. But the parties couldn't come to terms, and so the flight safety submitted a claim. The Air Force contracting officer rendered a final decision. This went to the Armed Services Board of Contract Appeals, and the subcontractor flight safety said that the Air Force couldn't challenge the markings because it was undisputed that they were developed at private expense. And some of the language in the clause and the regulations seemed to say there needed to be evidence that contesting that the data was developed at private expense in order to bring a validation challenge. They also argued that the markings were permissible because this was commercial technical data instead of government unique non-commercial technical data. And they contested that the drawings were OMIT data in the first place.
All right. And then the whole thing ended up in appellate court.
That's right. So one important point here, and something that makes this case unique, is that there was actually a settlement agreement between the Air Force and flight safety. And flight safety acknowledged that the Air Force would have OMIT type rights in the data. In most cases, a commercial subcontractor or contractor would argue, hey, that technical data is not really needed for operation, maintenance, installation, and training, or it goes beyond what's just needed for OMIT purposes and tells you how to actually manufacture the product. And so there's that exception for detailed manufacturing and process data. But here, the parties conceded it. The Armed Services Board ruled in the Air Force's favor. They said, look, the validation proceedings aren't limited to the source of funding. There are these categories that the government is entitled to receive unrestricted rights in, and it's acceptable to bring a challenge on those grounds as well. They also said that the markings were not permissible, that they clearly impinged on the government's license rights, given that they were unrestricted rights.
And by the way, there's nothing that would have precluded the vendor from continuing to use that same software with any commercial customer it so choose, so that it was not really restricting their uses of it for revenue elsewhere.
No, that's right. Whenever a government contractor provides technical data to the government contractor typically will retain ownership rights in the technical data and just grant the government a license. But if the license is very broad, unlimited rights or unrestricted rights, then it makes it more difficult for them to protect the data from commercial uses that are unauthorized. So the Federal Circuit here upheld the board's decision on all counts. They agreed that based on the statute and the regulation and the clauses that a validation challenge based on the category of technical data was permissible. And so the Air Force could challenge that this was OMIT data and they had unrestricted rights on that basis, even though the source of funding was admittedly all at private expense. They also reviewed the different legends that flight safety had used and said that they were impermissible because they affected the government's rights and didn't acknowledge that the government had unrestricted rights. So they said that the proprietary marking implied that government recipients were restricted because the data was confidential to flight safety. The language about expressly authorizing in writing wasn't required by the regulation or by the statute of the clause. Even the copyright notice, the appellate court said, was improper because the notice and surrounding text didn't recognize that the government possessed a copyright license in the data. That part was particularly surprising because even the other than commercial technical data clause allows for contractors to include a copyright notice, and it doesn't require a copyright notice to be listed when there's a data assertions table. So I think the distinguishing factor here may have been that they used the language rights reserved